Honorable Judge, the Honorable Judge Ray Guadagni. Ray was born and raised in Napa. He was an undergrad at UC Berkeley and received his JD from Hastings Law. Ray started practicing law in Napa here in 1975 with Guadagni, Gasper, and Flax. He was appointed court commissioner in 1995 and a superior court judge in Napa from 2001 to 2012 when he retired. Many of us know Ray just from his work in the community and also from being one of our favorite local authors and historians. I first met Ray at my Rotary Club, North Napa Rotary, where he spoke about his book, The Squeezebox Kid, and his upbringing in Napa's Little Italy, where some of our most prominent and influential Napa local legends grew up. And it was a different Napa that we know now and is a very important part of our history. He is here tonight to speak about his book, Napa Valley Case Files. So please take it away, Ray.
Thank you very much. I'm very honored to be here. I appreciate the invitation. I thought I'd start this by telling you why I wrote the book in the first place. Having practiced in Napa and also on the bench, I saw a number of serious criminal cases. And all the ones in this book, there are 8 chapters. Each one is an individual Napa murder. And they were ones that I wasn't a part of as a lawyer or as a judge in this book. And but I knew about them. I knew about all of them. I was alive for everyone except the first one, which was in the 1800s. And I always wanted to know more. And the only way to know more is to research it. And when I did, I thought each one that I selected was unique. And that's why I wrote about them. I want to start with chapter 1 because it's an amazing history of the attitudes of people toward Native Americans at the time. And it wasn't a good attitude. I'm going to be referring to the Native Americans as I talk as Indians. And the reason, and not to offend anyone, and I apologize ahead of time if it does, but all the research that I did refers to them as Indians. So that's what I will tell you ahead of time. I first learned about this case when I was a judge, and another judge, Richard Bennett, a close and dear friend of mine, came into the Department A chambers where I was situated and said, "Did you know that the very first case ever to the California Supreme Court came right out of Napa?" And I didn't. And he said, "In fact, the book is right around the corner in your the receptionist room." And he pulled it out, and it was just, trashed. It was leather bound, and the cases were in writing. The court reporter wrote it out with a pen. And so I read it and I was intrigued. And that's how I learned about the story. And when you see that, it really opens up your eyes to the times back then. So this was a case called, and by the way, it's listed in the law books as number 1, Cal. So it was called People versus Smith et al. And the story begins, it occurred before California officially became a state in September of 1850. This occurred, the story, in 1847, when early pioneers, Andrew Kelsey and Charles Stone, purchased a cattle ranch in what's now Lake County, and they had purchased it from Salvador Vallejo. Vallejo had hired up in Lake County Pomo Indians as his workers. Kelsey and Stone just took them over and used them and hired them. The difference, though, is Kelsey and Stone treated the Pomos horrifically. They beat them, they killed them, they raped them, they starved them even, which wasn't really good for getting work out of them. They raped Chief Augustine's wife. They killed a boy whose aunt sent him to Kelsey and Stone for more wheat, more grain, because they were starving, and they killed him. And white visitors to that ranch were testified that the Kelsey and Stone would bring Indians to play with in front of their white friends, you know, shooting on the ground to make them dance, hanging them by their wrists on a tree, just terrible things, and including sometimes killing them. Kelsey and Stone also made the Pomos build a large fence, or really a wall, around their village because they didn't want them going out at night or running away. And this was really incredibly ill-advised, not only for its cruelty to the Pomos, but because the Pomos were starving. They got this little bits of wheat and grain from the ranchers, Kelsey and Stone, and they couldn't go out at night to hunt because of this wall. And so this is how the case starts, again, in Lake County with a different tribe of Indians. They decided, the Indians, because they were starving, would get over this wall, a few of them, and take some of the horses from Kelsey and Stone at night, in the dead of night, and go hunting. The problem is one of the horses bolted. And so the two Indians came back and called an emergency meeting, and they discussed all the options. One was to deny that they knew anything about it. One was to admit it and throw themselves on the mercy of Kelsey and Stone and take their punishment. And the other one was, they're killing us anyway, they're torturing us, they're beating us, they're raping our women. Let's just kill them, let's end it. But when they said that, they knew full well what that meant. If they took that drastic option, they couldn't stay there because they would have all been killed. So they'd have to flee to the hills. And it was that option they selected. So early the next morning, 5 Indians went over to the ranch, and I think it was, let's see, Kelsey was killed right away with an arrow through their ranch, and Stone ran and was tracked down in some bushes and stoned to death. So after that, the Pomos realized their time was going to come, so they took off. And when they took off, they flew, they fled to the hills, and the Kelsey brothers, Kelsey had surviving 2 other brothers, and they vowed revenge. And so then that's how the massacre of the Napa Wapo Indians occurs, because on February 27th, 1850, the 2 surviving Kelsey brothers and a man who went by Captain Smith, although no evidence was produced he had any authority or was of any rank, and they attacked a Wapo encampment. The first thing they did is they ended up in Yountville. I mean, what I call Yountville, they ended up at George Yount's ranch. And Yount, it sounds like he was sympathetic to the Indians, and he said, because Stone and Kelsey, Smith and Kelsey said, can we take some of your men, which was common to give some of the workers to each other rancher. But Yount had already heard about something that had happened, and he had already wrote to the commandant in Sonoma. And of course, no phones, but he wrote, and the commandant wrote him back saying, I'll be there to check it out. In the meantime, don't do anything. So Yount asked for, show me your authority. And Smith said, I have authority, show it to me. Anyway, this went on, and no authority was produced. So Yount said, I'm not giving you any of the Indians. And then Stone still burned their village and then took off. They didn't kill any Wapos at that point. They headed north and ended up in Calistoga, where they ran into 2 brothers, or excuse me, 2 ranchers up there who were purchasers of land from Edwin Bale. you know, it was fascinating to me to hear all these names, Yount and Bale, and they got that again from Vallejo, who purchased it. These ranchers saw this, they didn't know anything about what had happened, and so they saw the Kelsey and Smith and just said, you know, yeah, you can take some of them and we can trade. And so he lined up all the ones, the ranchers lined up about a dozen Indians who he was willing to part with, because some he really needed. And when they got him out there, Stone pulled his weapon and shot one, and the person he shot was just sitting on the ground. They were Wapos, Napa Indians, had nothing to do with the Pomos, and shot him and yelled, "You've killed my brother," because to them, all Indians were the same, I guess. So they killed them and then killed about, the literature says anywhere from 10 to 12 Wapos, and burned down the village. And a band of Napa whites, including Yount, tried to come up to chase them away and got them out of there. But they were the next day arrested, 7 of them. They were called the Sonoma 7 is what they were referred to, and charged with murder. There was no jail, there was no courthouse. So they put them on the USS Savannah, which was anchored off of Benicia. And because Napa had no court at the time, Judge Stephen Cooper in Benicia heard the case on March 7th, 1850. And one of the key witnesses was Yount, and of course the other men up north. During this hearing, various witnesses testified, and at the end of the hearing, this was not a trial, it was a preliminary hearing where the judge's duty is to see if evidence of a crime has emerged from the testimony, and if it's likely that the defendants are guilty of that crime. And the judge, Cooper, found both prongs, that there was evidence of a crime and evidence that the Sonoma 7 were guilty of it. So he held them to answer and bound them over for trial. Again, the problem was there were no trial courts. And so he just put them on the USS Savannah, where they were to wait by court order for a trial. Well, the 7 had lawyers, and they took it to the Supreme Court on a writ of habeas corpus, alleging several issues. And I won't go into the legal issues, I believe, but they are in the book. But they lost all 4 issues before Justice Hastings, who was the justice of the Supreme Court at the time. And he denied them that. However, he did feel he had no alternative to allow bail, because otherwise they would have been jailed indefinitely, awaiting a trial that may or may not happen for years and years. So he allowed bail, and it was $10,000, which was a vast sum of money in 1850. Someone raised the money, they were bailed, and that's exactly where the case ends in the annals of the reports, because as soon as they bailed, they split and they never came back. And there's nothing in there about anyone going after them. People did, and there's reports that people traced some of them, including Captain Smith, up north, and they started the town of Union, which later became Arcata. So Smith and Kelsey and some of the ones that went there were the founding fathers of Arcata. But habits are hard to break, and so these guys killed Pomo Indians in Lake County and Wapo Indians in Napa County, and then they went after the Wyotes in Arcata. So they kept killing Indians, and that's where we lose the legal history of it. Although the thing is, the attitude is that the Indians were not universally recognized as being people, and in Lake County, even though these men were arrested, the government sent a captain of the army, Nathaniel Lyon, with a detachment of soldiers to find and eliminate the Pomo Indians who committed this crime of murder. The army was joined by local white volunteers, and they killed a band of Pomo Indians, by the way, nowhere connected to the Pomos that committed the crime. They weren't even in that area. They were on an island. And Nathaniel Lyon brought by boat a cannon and put it on there. There was no resistance. Most weren't armed, and it was a massacre. The estimates from the newspapers at the time was 75 to 100 Indians were killed, and it became known as the Massacre on Bloody Island. And in 1851, California passed a law compensating groups for expenses incurred when they went on Indian hunting trips. And I think, I think the best summary of the attitudes of the whites at that time in this county and the surrounding counties came from the Wairika Herald. This showed the prevailing view of the public. And here it is. Now that general hostilities against the Indians have commenced, we hope that the government will render such aid as will enable the citizens of the North to carry out a war of extermination until the last redskin of these tribes has been killed. Extermination is no longer a question of time. The time has arrived. The work has commenced, and let the first man that says treaty or peace be regarded as a traitor. I mean, that's horrible. That was by our newspaper editor. What I got out of that is given the prevailing views of the time, there is no good Indian but a dead Indian. That was a saying that went around. Giving those views, the most unique thing to me was why they were arrested in the first place. Why were they prosecuted in the first place? Because all the sentiment was against that, it seemed. And I'm really happy that Yount took a stand, citizens of Napa took a stand, and they got arrested. I mean, that I think it was the hope at that time when there was such a horrible view of Indians. And that's the first chapter and the first case ever in Napa County. I know we have time, so I thought and we'll have time for questions too, but I thought I would start on another one that was a big case in Napa. I was a very young lawyer at the time and had no part in it, but it really got my attention as a native Napan. And it was the case commonly called Willie the Woodcutter. It's chapter 2, and I called it The Puzzling Murder of Linda Keynes because she was the victim. The uniqueness, I thought, of this case was its tremendous secrecy, and you'll see what I mean. The judge, Judge York and Judge Blankenberg, they both presided over this case at different stages, and the prosecutor, which was the attorney general, because Jim Boitano, the DA, had a conflict of interest. All of them went along with Frank Dunlap, who was the defense attorney appointed to represent Willie the Woodcutter. All of them agreed that to ensure a fair trial, none of this should be open to the public. So every stage, and also Sheriff Earl Randall, he started it out. He would not give any details or any suspects. And so, and that became important because Willie the Woodcutter, Walter Williams, was very popular in St. Helena. He was a little 5'6" African-American man, and he just helped everybody. He traded things, he cut wood and would barter things, and was always there to help you. He was very popular. And so it really had the curiosity of the public on what went on. It was hard to believe that Willie did this. But again, people have different sides to them and we don't always know, our public doesn't always know your dark side. I came away, I'll tell you right now, I came away concluding that Willie was guilty. It was all circumstantial, but I felt it was. You may disagree. Willie never admitted it, denied it till he died. So anyway, this is on Friday, February 26, 1971. A 20-year-old co-ed from the Pacific Union College, Linda Keynes, who was a part-time student at PUC and also worked at the Meadowood Suburban Country Club. She didn't show up for work. And when that happened, by 2 o'clock that afternoon, her employer called Linda's landlady, and Linda still could not be located. And her roommate was Patricia Fink, and she called the police. And later that same day, the officers found Linda's Volkswagen. They found an abandoned, they found it abandoned on a turnout at White Cottage Road. And that was about 1.5 miles from Deer Park Road. The sheriff's deputies found a neatly folded bra and blue windbreaker near the car, which was positively identified as belonging to Linda. Almost 500 PUC students, volunteered to search the area. They found a piece of paper with Bible verses written on it and a silver bracelet that did belong to Linda, which she used as a key ring. By nightfall, Sheriff Randall had brought out a bloodhound and had the dog led the deputies to a bare footprint, but no one knew if that was really Linda's, so that didn't lead to anything. Deputies manned a roadblock on Howell Mountain Road and interviewed everybody that went in the area. The search covered close to 5 square miles, and following Monday, the search was called off by the sheriff, Randall, who indicated the office would continue to investigate the matter as either an abduction or a missing person. A week goes by, and again, Randall would say no comment. That's all he did. And police had some leads, but they were not divulged to the public. And then there was speculation rampant in here that the Zodiac, who was alive and well, killing people, may be connected to this, which sent panic to the PUC campus. And one reason for the rumor was he hadn't been caught, but also there was a PUC student killed up in Berryessa, and maybe 6 months or a year before, and so they were thinking maybe he's still around. One week after Linda's went missing, Sergeant James Monk and Deputy Ray Land of the Sheriff's Department, and by the way, Monk is on the cover page here, and by all accounts was just a wonderful, very good deputy, and so was Land. Anyway, they discovered the body on a sloping deer trail hidden under a pile of rocks and woody debris. And they determined that she had been murdered. So now Sheriff Randall's department had a murder case. Linda was lying on her back with her head inside an army duffel bag held in place by a wire around her neck, and a bloodstained American flag was wrapped around her head. Now is when the tedious process of sorting out the clues and sifting through everything and to try to find evidence. A murder weapon was not found. Eventually, deputies identified several possible suspects, but again, withheld the information from the public. And they did start searching some of the homes of these suspects, one of which was a 57-year-old woodcutter named Walter Boyd Williams, who had lived in the community since 1949. This is 71. So everybody knew Willie. And like I said, he was a little guy, not imposing, and a real helpful guy. So he was very popular. Law enforcement carried out the search on Williams' home on March 10th. 6 days later, they didn't arrest him. 6 days later, on March 16th, he was taken into custody. And again, Sheriff Randall was closed-mouthed about the evidence found at the crime scene. So this was really, Napa was very small in 71, and this was, and especially up in St. Louis, it was driving people crazy. A lot of people didn't believe it was him. A lot of people thought it was racism. On March 17th, Williams was arraigned in court. Frank Dunlap was appointed to represent the suspect. And a friend of mine, Malcolm McKenzie, who is a very prominent lawyer in town and a great lawyer. He was brand new, and you can find a picture of him, which really, and the picture fits Malcolm then, and he looks like he's out of the 70s. So he was dressed in facial hair appropriate for the time. Anyway, Malcolm was a young associate of Dunlap's. And in the criminal case, again, just like the other criminal case, you're entitled to a preliminary hearing. Again, it's not the trial, it's just for the judge to see if there's enough evidence to think a crime has been committed and enough evidence to believe that the suspect is guilty of the crime. And that was in front of Judge York. And at Frank Dunlap's request, you can exclude the public in a preliminary hearing. You don't see it too often. Most of the time, it's open to the public. It's favored to be open so people can see our courts and see what's going on. But Dunlap made the request in order to preserve the defendant's rights so it doesn't get so prejudicial against him that he can't get a fair trial and they may have to change venue or whatever. Anyway, Judge York granted that motion. So the preliminary hearing gets underway on March 25th. And I thought, I'm smiling because there's nothing to smile about really, but I'm smiling because I pictured in my head what the papers quoted back then, which is you had reporters and curious bystanders gathered outside in a very chilly rain, it was described as, peering through windows in the courtroom, attempting to see which witnesses were being called. At the end of the hearing, Judge York granted the request of the defense to seal the preliminary hearing transcript. Frank Dunlap wasn't satisfied that the preliminary hearing be closed. He wanted the transcript of the court reporter to be sealed, which makes sense, and Judge York granted that. So this meant that the ongoing news blackout surrounding the Williams case was going to now continue until trial. The trial opened up on June 10th, 1971, and curiosity about the murder and the evidence against Williams had reached a peak because up until then, nothing was released to the public. Sheriff Randall, as I said earlier, was closed mouth about the case, and so there were no transcripts that were allowed out of the preliminary hearing. The public knew very little except on how Linda Keynes died and what evidence they had against Williams. Rumors had been floating for months. Many citizens had a difficult time believing Willie could be a murderer, and some thought it was race. He was one of very few citizens of color in Napa County. His grandson told me it was 17 blacks in the county. I don't know if that's the veracity of that. But now at the trial, that will be the first time the evidence will be public. There's no need to keep it secret now. You got a jury was selected. You have a jury who claims they can follow the law and didn't know anything about the case, except that they knew there was this charge. And because Boitano had to get out of the case, John T. Murphy was sent from the state. He's a deputy attorney general, and he prosecuted. And from the outset, the atmosphere of the trial took on this almost circus type of atmosphere. I saw as a young teenager a movie called Inherit the Wind with Spencer Tracy, who played Clarence Darrow, and Frederick March, who was William Jennings Bryan. And the courtroom had slow turning fans. Many people were fanning themselves. It was really hot. And that was all in Inherit the Wind. And that's exactly what I pictured when you read the accounts of this. At trial, this partially convinced me. At trial, there was a piece of evidence admitted in, which was a canvas duffel bag. That was the one that was placed over the victim's head. And on the outside of the bag were the letters CAMICIA, Camicia. The police were able to trace the duffel bag. It belonged to a James Camicia, and he was an out-of-towner, and he used it when he was in the Army. In 1959, he gave the bag to his father-in-law, Ben Parada of Rutherford. Ben died, and Ben's widow testified in court in the trial that after her husband died, she decided to get rid of some of the items. And during the cleanup, she called Mr. Handyman, Willie, to haul away the trash. Included in the trash, Willie took the canvas bag, and that belonged to her son-in-law, James Camisea, many years before. They also found a gasoline can that was found at the site where the car was located. The police tested the gas, compared it to the gas found during the search at Willie's residence. Willie had kind of a junkyard and so he had always projects, and he had cans of gas, and they compared it, and it matched. The prosecution, one thing Willie testified to was that he did not know the victim at all. He didn't wave to her, as the roommate said that he was always waving. He admitted that he waved to the co-eds and the guys coming down the hill, and that made sense to citizens. That didn't sound suspicious because he was a friendly man and he was waving all the time, but he didn't know her. He said, I may have waved to her, but I didn't know who I was waving to. Prosecution proved that Willie did know Linda Keynes. They established that Linda Keynes and him knew each other to a degree, to the point where Willie seemed to have like a crush on her or something. He followed her home once. Linda went to her roommate and said, now he knows where I live. She tried to be real nice to him, but she didn't want anything more than just being a friend. And she was a little freaked out by him. But there was testimony, therefore, that they definitely knew each other for a few months at least. He testified in his own behalf, Willie did, and said he never killed anyone. The jury was put on a bus and went up into those hills and viewed the crime scene and the other locations. They went to Willie's house. They went to the areas that Willie said he was during this time. Willie was trying to establish sort of an alibi. But the case was all circumstantial, no direct evidence, and which isn't that uncommon, but this was all circumstantial. And he consistently denied he had murdered Linda. After a 7-week trial, it went almost 2 months, they convicted Willie of first-degree murder. On August 9th, 1971, Judge Blankenberg, who was a trial judge, sentenced Willie to life in prison. This happened on February 26, 1971. And exactly 7 years later, February 26, 1978, Williams died of cancer at San Quentin, exactly 7 years after the murder. He maintained his innocence to the day he died. So that was Willie the woodcutter. And I could do one more case, and then we could have questions and answers. This one was a situation where it was in the 80s, and domestic violence, as far as defenses to domestic violence, when there's a thing called the battered woman syndrome. That was in its early infancy as far as being a legal defense. It'd been long before discussed. And in this case, it's very interesting because in the early 80s, it apparently wasn't that accepted. And then later on in the 80s, it was well accepted. And you'll see that if you read this chapter. On April 4th, 1984, Sally Blackwell, this is People versus Sally Blackwell, she telephoned her husband's brother to report that her husband had been shot by her. Mrs. Blackwell said the shooting had happened after her husband physically assaulted her. But the thing is, the investigators got right over there, and they found no signs of a struggle, absolutely nothing. And Mrs. Blackwell didn't require any medical attention. She was unhurt. No bruises, nothing. She said she was physically assaulted in the bedroom. Nothing, everything was neat and clean. When she was questioned by the police, after that questioning, they booked her for first-degree murder, and she was held without bail. Judge Quigley, John Quigley, another well-known Napa judge, presided over the preliminary hearing. And remember, I know I'm repeating, but the preliminary hearing is just to see is there evidence of a crime, and also evidence that the defendant is guilty of that crime. If there is, it goes on to trial. So he found that there was, those two prongs were met. And you can completely see why Judge Quigley would have done that. Mrs. Blackwell had fired a full chamber of bullets from a 38 caliber revolver into her husband while he was in the bathroom at their home, some of the bullets in his back. He was unarmed. So Judge Quigley really had no choice. You can see why that would happen. Mrs. Blackwell's attorney, J. Roland Wagner, a very good defense attorney by Napa standards, and by any standards, I felt he was really good. He contended that Mrs. Blackwell had killed in self-defense, and he wanted to bring in experts on battered woman syndrome because it was around. It just hadn't sunk in enough. So because it was a relatively new field of study, prosecutor Scott Lestrange made a motion to bar this testimony. Judge Philip Champlin, who was the judge, denied the motion, saying the public doesn't have general knowledge about this, and so this will assist the jury. During jury selection, both attorneys and the judge questioned potential jurors about domestic violence and alcohol abuse, and many prospective jurors were excused. A lot of people are touched by domestic violence or a lot with alcohol. Jury selection had to actually come to a halt when the court ran out of potential jurors. Judge Champlin was quoted as saying, "This is the first time in the history of the court that we've exhausted that many jurors without being able to pick a panel." 60 potential jurors were summoned for a different trial before Judge Consgard. I like dropping the names of all these icons that I knew. And they were assigned to Judge Consgard, and they were diverted to the Blackwell trial. And finally, a jury was selected. At the beginning of the trial, defense attorney Wagner said, Mr. Blackwell was a charming man. He was loved by many in the community, but it was a Jekyll and Hyde situation when he had too much to drink. And Mrs. Blackwell was in great fear of her life on April 4th. Because it wasn't so well known, that doctrine, Jim Wagner thought he would bring in an attorney who was devoted to women's rights and could prosecute the battered women's syndrome. So he called in Diane Price, an excellent attorney who became an excellent judge, but at the time an attorney, and she presented evidence on behalf of the defendant on this battered woman syndrome. And it was opposed by the prosecution. They argued it was a therapeutic tool and nothing more, but Judge Champlin disagreed. And after she presented the expert testimony on the subject, Judge Champlin ruled that the public doesn't have general knowledge about this and denied the motion to bar the evidence. So, and you need to know the bulk of the literature in this area, this malady of battered woman syndrome, was only published in the 80s. So in the late 80s, it was way more accepted. That's my belief based on this trial. Mrs. Blackwell testified that Mr. Blackwell grabbed her, threw her down on the bed, and held a gun to her head. And she said the shooting was a culmination of several years of physical abuse. Lestrange said there was no evidence that she had been assaulted that night, and the killing was premeditated, not self-defense. On December 28th, 1984, the jury convicted Sally Ann Blackwell of second-degree murder. She was reportedly the first woman in California convicted of murder using the battered woman syndrome as a defense. Judge Champlin did what he had to do. She's convicted of murder. She's a murderer by law. So he sent her to life imprisonment. She did prison for 3.5 years fighting for justice. She spent everything she got. She got a new attorney, not a public defender, even one of Roland Wagner's tremendous quality. She got Rowan Klein, and he did an exhaustive search and discovered that one of the jurors at her trial had lied to Judge Champlin and to the attorneys. And so based on that, she was granted a new trial. Apparently, she meaning this juror, was a battered woman herself and didn't disclose it because the question was asked. She didn't disclose it. And when she didn't disclose it, then it turned out the other jurors were polled later after Sally was convicted. And those jurors said, oh, she was very dominant in the deliberations, said she was a victim or survivor of domestic violence. And you don't need to murder the guy. All you got to do is kick him out, divorce him. And that's what she should have done. And you should convict her. I don't believe her. And the other jurors, I guess they were impacted and influenced by that. So they did convict her. So then Sally gets a second trial. And in that second trial, Sally Ann Blackwell was acquitted. Her attorney argued the shooting was, quote, justifiable homicide. When her husband returned home from a Napa bar, he threatened Miss Blackwell with a gun to her head. And she had a gun to her head and heard it cocked. And she thought she was going to die. Mr. Blackwell left to get another drink, and he left the gun, his gun, on the nightstand, went and mixed himself a drink, and then stopped at the bathroom to urinate. That's why it happens in there. She picks up the gun, goes in, and she testified it was kind of gray and vague, but she unloaded the gun on him. And she fired 5 shots, 3 struck him. And Rowan, this is the new attorney, Rowan Klein, argued that Mrs. Blackwell was battered that night and was in fear for her life, and that therefore her actions were justified. They accepted that. The jury acquitted her in less than 2 hours on that second case. I kind of have a theory that people knew a lot more about this subject now. We're much more able to see how someone who's been battered and battered and battered would think on this occasion, he's got a gun now. I'm going to die tonight. And knowing that took action, and it would be self-defense. And that's just my theory, but that's what happened in that second case. And that was at the end. That was like in 1988. Mrs. Blackwell, just to end the story, she remarried and moved to Arizona. And when she left, she was interviewed by the Register, and she said, what I would tell women who are in a battering situation now is to tell someone, tell anyone, don't keep it to yourself. And the other thing I was curious about is, as for the juror who did lie, the Court of Appeal, which reviews the trial court, the Court of Appeal suggested that juror be charged with perjury, but ultimately that did not happen. I went through the records. I didn't see any motion to Judge Champlin to hold her in contempt. He didn't do so on his own, not that he should have, but I'm saying it looks like that just did not happen. But I wondered, because that was it cost our county a lot of money. It cost this poor lady 3.5 years in prison. So, but I guess she skated. I know it probably wouldn't be a popular thing for judges to hold registered voters in contempt, but lying under oath is a crime. So that's my third one, and I have to stop now and take some questions and answers if you have any.
Ray, thank you so much. This has been fabulous.
Thank you.
I'm fascinated by, of course, California #1, the story of the massacre of Agua Caliente, the village up in Calistoga. I have several questions to start that have been sent to me, but so let me start with, when you review the case of the Kelsey brothers, and that, how much can you see, or are you even looking for, the fact that the Kelseys were from a slave state to begin with, and thus their attitudes towards the first people were pretty much in keeping with racism and slavery, and that, versus the people like Yount, who had been living in New Mexico prior to that, Hargrave, who was the other farmer or the other rancher that was with him when they kept the Kelseys from massacring the village Mayakama. Is there anything in the records where you could really do the demography study to see where these attitudes, how these attitudes shaped or were shaped as part of Napa?
It's probably, it is possible, but my whole plan at this time was to write a chapter on each case. And I didn't want it to be that lengthy, other than to say maybe where they came from or what the prevailing attitude was. So it isn't, I didn't do that deep of a dig, but yeah, I'm sure it would be possible to say where were their roots.
And I guess the second question that I saw that came to me tonight was, I think the last story you tell is a really wonderful story of how changing perceptions on people change how we look at different verdicts. In your tenure, you had an illustrative career, but in your tenure, how often do you think that's the case, where we move from this kind of thinking to that kind of thinking? So if a trial starts here and in maybe 5 years later, it comes back, that there's a change of perspective based on how the whole country moves.
Yeah, I mean, that certainly happens. The law evolves. There are rules. A 0.10 is presumed to be under the influence. Now it's 0.08. I mean, things, and that's all science. Polygraph tests are still not admissible. Maybe someday they will be admissible. There are things that go on throughout the throughout the times. In this case, she was she was serving her sentence illegally. So when she had an actual legal point, then it was acted on. If the law changed, 100 years later, that isn't going to help the person, of course. So anyway, yeah, things change.
Yeah. I would encourage anyone who has any questions, please type them in the chat room, and we're helping. It's here. Did the Kelseys and others involved in the killings ever face any justice themselves or their families?
Not that I found, at least in this case. The one Kelsey was killed by the Indians, of course, and the other two brothers were arrested for murder and then bailed and never saw him again. I found nothing. There's a few old newspapers that printed things at that time, and nothing that I found where any of them were punished.
Yeah,
this for sure.
Well, I know that Captain Smith was murdered, or he was killed in one of the raids he did in Northern California. And I do know that the Kelsey brothers eventually moved to Southern California to recruit for the Civil War for the South, because they were very pro-Confederate. Yeah, so they spent their later years in Los Angeles area recruiting for the Confederacy.
Yeah, when you think of the times, this was before the Civil War. It was before we were a state.
Mm-hmm. Yeah, although not before we were under. I mean, we were under from 48 on. We were under Marshall. We were under military rule, Fremont and those guys. So yeah. Any other questions that anyone might have? Because I have one that I'm keeping for Ray, because it's I'm very excited about Ray's next phase. So Ray, tell us about your next, you have so much energy and are so interested in so many things. What is your next plan of action?
Well, in writing, I'm writing about a case that just really tore up a lot of Napans. I think probably the most victims of any case in Napa County. It was cited as the largest fraud case of any case in Napa County, and that was the Lenvest case. It started that they were first called Napa Valley Mortgage, and they became Lenvest. And in a nutshell, it was a Ponzi scheme. And the founder of Lenvest, David Hansen, was a member of a Christian church here in Napa, and was the treasurer of the church, and was got a lot of his business from churchgoers. But it didn't end there. I mean, we had a couple of police officers who invested. He was paying like 14% interest on your account, whereas in the bank at the time you could only get 5 or 6%, which we'd kill for now. But it was like 5, 6%, and he was paying 13, 14, 15%. So the greed took over. And if something sounds too good to be true, it probably isn't true. But people, especially the elderly, they had, so many of them in this case either had small savings, which they lost it all, or they didn't even have savings, but they had paid their house off and they were proud of that. And he would talk them into refinancing. So their payment went from 0 to $1,300 a month or something, and they'd put $100 grand in it and then lost it all. And there was a ton of counts, 130 counts or something were filed. It was a complex case. So many people were damaged that it went to Yolo County for the actual trial. And there were so many sideways issues that happened in the case. Like the bankruptcy trustee, Charles Duck, was a crook, and he was exposed during then. He was removed from office and charged with embezzlement, and he mixed money up, including, they think, Lenvest money. So Charles Sims took over, and he was an honest man and was helpful, but I don't think they got anything back on their return. There was some of the investigators in the case feared that some of these people had been so devastated that they might become violent, and they found a few guys they had to watch. It was terrible. And part of my problem is some of the victims were in their 80s then. They're clearly deceased now. And I would like to know if any of their family is left who might remember their suffering or the impact on the family, because many of them lost their homes and they ended up in trailers or something that wasn't, or they couldn't put their kids through college. The younger ones in the 40s, that's some of them I've interviewed, that's what they were saving for, was to give a good life and good education to their kids. And they not only lost all that, they had to sell their home and move and to cheaper.
So are you still looking?
Yeah,
Ray, for people?
I am.
Well,
I've struck out too much, on victims who have passed away.
Well, we're going to put this up because we would love to help you. So for anyone who knows someone, if you or someone was impacted by the 1991 Lenvest Ponzi scheme, we'd like to hear your story. I mean, this is what's the enrichment of history, by telling stories that are both good and bad, by understanding the full story of any town or any community. And so if you do have it and you're willing to share, please contact us at info@napahistory.org, and we will forward all your responses to Judge Guadagni. And this is to help his next book, Better Tell the Story, Better Hear the Unheard Voices of Napa. I can't think of a better way for us to really help gain better history and gain who we all are. Ray, I'd like to thank you for your work tonight. As always, it's fascinating. I sit on the edge of my chair every time I hear you talk, so that's so wonderful. I'd like to thank all of you again for attending tonight. If you haven't bought your tickets for the Halloween soiree, you get out there and buy your ticket, because it's gonna be so much fun. We're gonna have costumes and games, and we have music. We have DJ Danielle at the helm that night. Woohoo! And so we have And we have our neighbors, both Leon Brendel and Mia Carta, and they have stepped up to help us throw our first fundraiser, our first public fundraiser in over 3 years. So I hope you all will join us and join us next month. If you haven't looked at our events calendar, please go see it. We are partnering next month with the Napa County Public Library and the Napa Genealogy Society. And we would like to welcome Louise Dunlap, who has written a book on her family and the inherited silence. So the whole idea of colonizing, and to play up on what Ray has talked about tonight, the idea that both the Mexican and US colonizing of the Napa, without question, had very, very grievous effects on the first people who lived here, obliterating their culture, moving them off their land, and creating great grief for generations to come. So I hope you'll join us next month. It's going to be at the Napa County Library in December. We are incredibly excited to welcome both Deb Feldman and Kristen Harnish, two fictional authors who have written books, one who stayed in the Napa Valley to write their book and the other one who wrote about the Napa Valley. And it's a very well published book called The Vintner's Daughter. So I hope you'll all join us in the coming months as we continue our lecture series, because it's so much fun. Thank you again. I hope you become a member of the Historical Society, and thanks for helping us keep history alive. Thanks, Ray. Thank you everyone for tonight.
Thank you.
Applause.
See ya.
Thank
Bye-bye.
you.
Thanks, Ray. Thanks, Shelley, Kelly,
Thank
everybody.
you. Thank you
Good
so
night,
much.
everyone.
Good night.
Night. Great job, Shelley.
Thank you all. Thanks so much. Thanks, Danielle. You did it. You did a great job. Thank
Yeah,
you very
Danielle's
much.
awesome.
Happy birthday, Liz.
Oh, thank you. Okay, we're having
All right.
raviolis and maffatis, so we'll go back. We're
Oh,
now gonna have seconds, so great
Yeah,
job. Thank
okay.
you.
We'll
Bye.
see y'all. Night, night.